Employers in the UK are under an obligation to prevent illegal working and are prohibited from employing anybody in their business who does not have the right to work in the UK or who's in breach of their conditions to stay in the UK. Employing illegal workers is a civil offence if committed negligently or a criminal offence if committed knowingly. Employers can face a fine of up to £20,000 per illegal worker, as well as other consequences such as criminal prosecution, revocation of the business's Tier 2 sponsorship licence, and reputational harm. To prevent employing illegal workers, employers must carry out right-to-work checks to verify that all of their employees and prospective employees have permission to work in the UK. If employers carry out right-to-work checks correctly, it will provide them with a defence if there are later any issues with the immigration or working status of an employee. There are two important points to note here. Firstly, right-to-work checks must be performed before an employee begins working for an employer. And secondly, the employer must carry out checks on all employees, regardless of their nationality or immigration status. This includes British nationals, EA nationals, and overseas workers. Singling out any class of individuals can amount to discrimination and constitute a breach of the Equality Act. A correct right-to-work check consists of 3 steps: obtain, check, and retain. The first step is to obtain an original document or original documents which establish an employee's right to work in the UK. The documents required depend on an employee's nationality and immigration status and must be in accordance with the Home Office's lists of approved documents, which can be found on the government website. The second step is to check the validity of the documents in the presence of the holder. Employers are not expected to be experts at verifying the authenticity of identification documents. They are only required to do what can reasonably be expected of them and will be liable accordingly. The third and final step is to make copies of the respective documents and securely retain these. Employers should also make a note of the date the right-to-work check was carried out and, if required, of the date or dates when follow-up checks must be made. The documents must be retained for the duration of the worker's employment and for an additional 2 years after they have left the business or organisation. If you have any questions about any of the issues addressed in this video, please get in touch.